Lordship, I take indulgence of your Lordship. Item number 5, your Lordship, is a parted matter, and my friend has come from Guwahati. I have concluded my portion. He says he will take 10-15 minutes. So if it Lordship please to upgrade it and take it, because otherwise last time there was a order to list it as a first item, but last time it came for mediation, whether mediation is possible or not. So according to my friend, he will take 10 to 15 minutes. बोलिए आप. Yeah.
We'll have to see, because you see, if that indulgence is given to you, and those whose names are, rather whose case are in the list,
So it is slightly,
might take
slightly different, Lordship, because it is a parted, and
there are, see, some of these cases are also part heard, though not specifically noted. Let us see. It might be caught up.
well,
If other cases,
Right.
would take some time,
right.
then the next case thereafter will be taken up.
Obliged.
May I please, Your Lordship? I beg to mention item number 4. We need some time to research, Your Honor.
You have 4?
Respondent number 2.
This matter has been heard.
No, Your Lordship. No, Your Lordship.
Any objection
Respondent number 1, Lordship.
on plea made by Mr. Counsel for the respondent number 2 seeking accommodation? That is adjourned. Listing after 2 weeks.
Much obliged, Your Lordship.
Daily list item number 1. Your Lordship, Dr. Mozika is actually on legs before courtroom number 2. Lordship, may kindly take this up at the end of the boat.
End of the vote.
Actually, they can also be here while they can make a reply. You can continue because this matter has been pending for too long, Lordship. And on the last date, I've argued halfway, not halfway, I mean somewhere. And still, because of other problems, this court could not take it up. If I can start, Your Honor, or perhaps the other item, which my colleague will be after that item also.
Okay. Pass over.
Item number 2.
Yes.
Please, Your Lordship. Your Lordship, the conducting counsel is on legs for the Honorable Justice HS. Thank you.
Pass over.
Item 3. Also, Your Honor. Your Lordship, item 3.
2 and 3.
2, 3, may it please Your Lordship. Item number 2 and 3, Your Lordship. I think it can be referred, Your Lordship, to mediation.
Your Lordship, we are ready for mediation.
It can be referred, Your Lordship.
Okay,
Let them have a try in the mediation, Your Lordship.
Okay. When the matter was called up, Ms. Learned Counsel for the petitioner, as well as Mr. Andy Shulai, Learned AG, appearing for the state respondent. Who's for respondent 5?
Lordship, is a private respondent. This is.
But are they willing for mediation? Will it involve them, affect them Well, all parties have to be on board.
Yes, Your Lordship.
Mr. Paul is here.
And what is her name? That no? But they are not here, Your Lordship.
You try to contact Mr. Paul or get his consent if parties agrees. I thought only two parties are involved.
It can be referred, Your Lordship.
We'll take it up on the next call. We'll take it up after, on the next call.
Lord, all right.
Try to find Mr. Paul in the meantime.
Item number 5.
We're so fortunate to get our turn naturally, my lord.
I understand how things will turn out. So.
May it please your lordships. My lord, the first issue my learned friend raised, that the insurance company cannot contest the case on its merit until and unless the tribunal has passed an order under section 170 of the MB Act. My lord, the law is no more res integra that has been settled by the Apex Court way back in 2011. My lord, where the Apex Court has very clearly stated. My lord, my lord, very lightly possibly has taken that point. That point is not there at all. My lord, I am the decision which I'll be relying on, I am just submitting to your lordships. The first decision on this point is 2011-10 SCC 509.
Yes. What's the citation again?
2011-10 SCC 509. The lordship may see paragraph 14 and 15.
Yes.
I'll read paragraph 14, my lord. Last two lines.
Yes.
When an insurer is impleaded as a party respondent to the claim petition, as contrasted from merely being a noticee under section 149(2) of the Act, its rights are significantly different. If the insurer is only a noticee, it can only raise such of those grounds as are permissible in law under section 149(2). But if he is a party respondent, it can raise not only those grounds which are available under section 149(2), but also all other grounds that are available to a person against whom a claim is made. It therefore follows that if a claimant impledes the insurer as a party respondent for whatever reason, then as such respondent, the insurer will be entitled to urge all contentions and grounds which may be available to it. Now, your lordship will find from the memo of appeal at at page 23, my lord, your lordship can see.
Yes.
This is the claim petition. And at page 23, your lordship, annexure 1.
Page 23.
Page 23 of the
paper book.
No, not in the paper book, but in the memo of appeal, MSC Appeal 1 of 2025. Memo of appeal, it has not been enclosed.
But why?
Memo of appeal to the end. There's extra copies there, my lord, in your lordship file.
Or whatever the case may be, you see, everything has to be contained in the paper book.
It is has to be, but then it is not included there.
It's included in the
No, to claim petition. Anyway, from the claim petition also, your lordship can see it.
Okay.
Page kitna hai? Claim petition.
Page number 1.
Your lordship may see.
Just refer again to the memo of appeal.
Yes, Your Lordship has seen that memo of appeal,
Page?
page 23. This is a claim petition, MSC case number 21 of 2014.
Yes.
The respondent, Your Lordship will find the New India Assurance Company Limited is respondent number 3.
Yes.
So therefore, when the insurance company has been implemented as a respondent, my lord, although there is no leave application we have filed, but then there is no order passed. But nonetheless, my lord, if they are as a respondent, they have been implemented, my lord, on all the grounds the apex court has said, we can argue. But then if they are noticee, that is in terms of section 149(2),
Yes.
Your Lordship will find they are not required to be made parties. But then if the court issues a notice to explain certain things, in that case their rule will be confined to under section 149(2),
149(2).
that is in regard to violation of policy and all that. But then here is a case where we have been implemented as a respondent, so therefore in terms of the apex court's order, we are entitled to argue on all the points, save and except 149(2). Even
See, provided matter has proceeded ex parte against the...
yes, it is ex parte against the owner and the driver. So therefore, my lord, my learned friend also did not argue much on that, although he has taken a point and lightly he argued. Now this is the preliminary point taken by my learned friend. Then, my lord, I'll...
But Mr. Datta, if you are, you see, at this point of time, you would still be, making a stand on behalf of the insurance company,
My lord.
who would, stand in the stead of the owner and the driver.
Right.
But if I understand correctly, Mr. D is appearing for one of the... Are you appearing for? Then...
No, earlier they were ex parte.
Yeah, but now, see, I just noticed that. Because
Right.
I've noticed Mr. D. Now he is appearing for the driver, who was issued notice by the, by the appellant in this, in this
In the appellate
forum.
stage. Yes.
So how do we reconcile that?
My lord, that point will be different. My lord, in the trial stage, if your lordship look into
Yes, trial stage, yes, you are there.
Yes.
You have taken,
And we have filed an application also for the
Yeah,
leave.
filed whatever.
Somehow no order was passed.
Okay.
Now, in that eventuality, if the respondent are implemented as the respondent in the claim petition, then our rule is that we can argue on all the points.
True.
Even it is not limited up to 149(2).
That is accepted.
Yes.
Like you said, no longer accepted.
My lord.
But the point is, in this forum now,
My lord.
he is appearing. You will be arguing on his behalf. Technically.
I'll be argued on behalf of the insurance company.
But taking his defense.
Right.
Now he will also argue, taking his own defense.
No, since he is there, my lord, I am not required to argue. He can argue.
Okay, the only thing is that is what I am trying to
Right.
establish the fact that if you argue, fine, you can. But as far as he is concerned, perhaps you are excluded from
Yes.
tracing points.
That's true. That's true, my lord.
So now you are confined only to policy.
Yes.
The
So
policy,
only, my lord, your lordship will find whether this claim petition is maintainable at all. That's the question. my lord.
Any party can raise that issue.
Yes.
But as far as let's, for example, take the case of rash and negligent. The issue of rash and negligent conduct
Right.
by the driver, or owner, whatever it is. As far as the driver is concerned, you cannot take that point here.
Right. Your lordship is right. Very correct.
So that is settled.
Yes.
Please proceed.
Now here your lordship will find very short question involved is whether the legal representative of the tortfetchers I will say the deceased himself. Now he wanted to say that he is the registered owner. Whether he is a registered owner, there is another question. Now my lord, if a wrongdoer, I mean the tortfetchers, he meets with an accident and my lord, something happens to him, and if it is for his own negligent driving, then the law is emphatically very clear. The legal representatives are not entitled to get anything. My lord, this is the only point your lordship will like to adjudicate the matter. Now, first thing your lordship will find whether he is registered owner and if he is not a registered owner, that whether he is entering into the show of the registered owner. Now, your lordship will find the deceased was not a registered owner. Your lordship will find that from page 99 of the paper book. This is the seizure list. Your lordship will find the description seizure in the middle part. Vehicle bearing number ML05D7379, that is the accidental vehicle. Lordship got it.
Page 99.
Page 99.
Seizure list, yes.
Now your lordship will find in the middle description of seizure.
Yes.
Vehicle bearing number so and so, chassis number so and so, engine number so and so, color red, class of vehicle LMB car.
Yes.
Now the number 2, registration certificate of the vehicle number so and so in the name of Srimati Mildoris Raji. Now she was the registered owner, and apparently he might have borrowed the vehicle for riding. Now in such a circumstances, my lord, Appeals Court has said, if he has borrowed the vehicle, then he is entering into show of the owner. And my lord, your lordship will find section 147 of the Motor Vehicle Act. I will take your lordship to that. That it's a, my lord, general insurance, it's not a life insurance. Now what is the, whether anything happens to the insured, whether the insurance company liable or not, the phrases given in section 147 will make it very clear. Your lordship may see section 147. Has your lordship got that?
Yes.
Requirements of policies and limits of liability. In order to comply with the requirements of this chapter, a policy of insurance must be a policy which is issued by a person who is an authorized insurer and insure the person or classes of persons specified in the policy to the extent specified in subsection 2. Then Roman 1, this is very important, my lord, against any liability which may be incurred by him. Incurred by him means, my lord, incurred by the owner. In respect of the death of or bodily injury to any person, including owner of the goods or his authorized representative carried in the vehicle, or damage to any property of a third party caused by or arising out of the use of the vehicle in a public place. Now the question would be, my lord, if it is the liability which incurred by the owner, that means third party liability. Supposing I drive my vehicle and on the road something happens, somebody dies, then my lord, that's a different story, my lord. Supposing something happens to me, now I die or I get some injury and all that. In that case, my lord, insurance company is not liable, because what, by giving a premium, the insurance the insurance policy which we get, that is for the liability which I will incur. That means third party property or somebody dies out of the accident takes place because of my rash driving. In those circumstances, my lord, the policy will be covered. Now something happens to me, that's not covered by that policy because it's not a life insurance policy. My lord, the insurance company insures the liability of the insured, not the insured. So that is the concept, my lord, that has been explained very nicely by one decision of the Madhya Pradesh High Court. My lord, I haven't find such a beautiful description to explain this phrase. My lord, what will be the liability of the insurance company? The phrase is insures the person or classes of persons specified in the policy against any liability which may be incurred by him. Now that's the thing which has been explained in that decision. I will take your lordship a little later. Now here your lordship has seen he is not the registered owner, but then his position will be, in the legal parlance, akin to the registered owner. because he is entering into the show of the Melody insured. Now, in the instant case, and your lordship will find the important now if you look into the evidence of OPW 2 and 3, they are the vital evidence, they are the eyewitnesses. That will make the picture very clear. The 2 and 3, they were at that relevant time, they are the police personnel. They were given the duty of Naka checking. Naka, as your lordship understands it, originates from the term Hindi. That is, Naka means, my lord, check post and the road block. It's not a free moving road, that the police will be there and they will stop the vehicle, they will check, and then they will free the vehicle if it is they don't find anything. Now these are the two witnesses. They have checked, they have first signal to stop, but he did not stop in a rash and negligent manner by crossing other vehicle. He went ahead, and from opposite direction there was another truck. He just, in such a manner he has dashed, he collapsed there itself. So here is no question of my learned friend argued that the res subsaliquator will come. When there is a plenty of evidence, res subsaliquator has got no place to play here. Now, my lord, I will read the eyewitness, that is OPW 2 at page 39 of the paper book. He was on duty on that day. He was the sub-inspector of police.
Yes.
My lord, I will read. This is not a long judgment, small one. I have received summon to appear before the court to give evidence in this case. On June 2014, I was posted at Nangpur police station, in the police station, and I was going probation. On 11/6/2014 in the evening, we were detailed by the OC Nangpur PS for conducting highway vehicle checking. SI John Sangma was with me and some armed personnel whose names I do not recall now. In course of the vehicle checking at the highway, we stopped many vehicles, and everybody obeyed our signals and stopped their vehicles for checking. Suddenly, one red Maruti car in a rash driving came from Barneyhat side towards Shillong, and when we signaled the vehicle to stop, it did not stop but rushed forward and dashed the stationary truck on the opposite side. After that, we informed the IC traffic and called the ambulance and took the injured to the hospital. This incident I have witnessed with my own eyes, and according to me, the red Maruti car was at fault. Now the cross, they could not bring out anything, so I am skipping. Your lordship may then come to page 41, the evidence of OPW3. He is also eyewitness. He is UBSI John Sangma.
Yes.
On 11/6/2014, in the evening from 7 p.m., we were on highway duty for Naka checking of all the vehicles passing through Nangpur highway. At that time, my colleague UBSI L. Kharvin was also with me on duty, and this duty was assigned to us by the officer in charge of the Nangpur police station. At the relevant time, we were stopping the vehicles through that route and checking the vehicles. Suddenly, one red color Maruti vehicle going towards Shillong was stopped by us, but it did not stop. The said vehicle was driven in a very rash manner and almost hit my colleague who tried to stop it. The said Maruti car did not stop at our signal and went forward and hit one truck which was parked on the side of the road. The accident took place at around so and so, just nearby, standing on the road below Nangpur. We rushed to the spot and looked out the driver of the Maruti car as well as the passenger. In the meantime, the traffic police came along. with ambulance and took the injured to Nagpur Civil Hospital. At that point of time, we do not know whether the driver of the Maruti car was alive or not. I have seen the incident with my own eyes, and it was the fault of the driver of the Maruti car. Now, the cross-examination by my learned friend, your Lordship will find that they have brought certain facts against them. My Lord, your Lordship may kindly come to paragraph 13, my Lord, at page 43.
Yes.
It is a fact that when the vehicle was parked on the roadside, the driver of the vehicle is supposed to switch on the parking lights which blinks. Then the question whether you will agree with the suggestion that the person who is sitting beside the driver of the Maruti car is a better person to know the manner into which the accident took place. Now the answer, your Lordship, kindly see. The person sitting beside the driver of the Maruti car was drunk. Now both the person who was the occupant of the Maruti car as well as the person who drove the vehicle, both were drunk. My Lord, your Lordship, kindly see for a moment the PM report which reflects that the deceased was also drunk. Your Lordship may kindly mark at page 100Q of the paper book. Your Lordship will find item 4. In the top it is written abdomen.
Page 100.
100Q. आप ही तो लिखा 100. You have changed it or what?
Because
Oh,
there was
now
some
possibly they have changed it. It's not Q, it's B. मेरे बताया नहीं क्यों? B ना? Well, it is 100B. उसमें ये corrected है. Yes, your Lordship will find in abdomen, then column 4, my Lord, stomach and its contents. Your Lordship seen that. Now here, healthy and eligible digested food matter smell of alcohol presence. Now the deceased was under the influence of liquor, as it make it clear from the PM report, and the person who was the occupant in the car, my learned friend was kind enough for us. He has brought that. It was not necessary for him to put that question, and the reply of the police was that he was drunk. Now they are eyewitness, they are handling at that moment because they are on the spot, they were doing that duty. So when both the persons are drunk and this person, he became the eyewitness, he was injured, he said I was badly injured. In the cross examination he has stated, in the examination chief, in the cross examination when the question was put to him, he said no, I was not seriously injured. Now this person, he was not consistent what he is saying, and then my Lord, being the occupant of the car, it was his bounden duty to inform to the police, to file an FIR. He did not do anything, and he became a eyewitness, and he stated something after so many days, and therefore the learned trial could rightly did not rely. Now the evidence of the two police personnel, they were the eyewitnesses, and they were there, what they have stated, it is quite worthy to accept, and therefore the learned court has accepted. Then the next question at column 17, your Lordship, kindly see. I have seen that the truck which was parked had its half light on. Now they have clarified that the truck which was standing there, it was half light was on. So this much so far the evidence of the eyewitnesses. Then my Lord, your Lordship may see the first FIR, because my learned friend argues much on that it was a UD case. It was not converted into FIR. Now, UD case, my lord, even the accidental case also sometimes your lordship have seen that even in accidental case also registered a UD case. Now there will be investigation by the police. If the police finds there some sort of cognizable offence like murder and all that, if that sort of things are there, then it is converted into FIR. So here, my lord, nothing of that sort happened. So that's the reason your lordship can see the GD entry of what is the contents therein. They want to say that this is the first FIR at page 97. I am to inform you that on 11/6/2014 at 7:45 p.m., I along with staff detained a vehicle checking in front of Nongpu PS to detain two Tata Sumos which fled away from Barnihat to avoid checking. While checking the two Tata Sumos at 9 p.m., one Maruti car number AML05D7379 was coming in a very rash and high speed from Barnihat side, overtaking the vehicles, being checked and dashed against one opposite coming numbers AS01 so and so, which opposed on the scene the speeding Maruti car, as a result of which the driver Sri Colleen Varjari, aged about so and so, died on the spot, and one occupant, namely Sri P. Milliam, aged about so and so, sustained injuries and shifted to Nagaon Civil Hospital. Now this was the first FIR. It was filed by OPW3, that is John Sangma. And the final report your lordship will find at page 98N. Is it 98N? Check color. Yes.
98.
Just a minute, my lord. We're checking whether it is.
Final report is 101.
No. 102T. Final report. This is 102C. My lord, 102C. इसमें correct है 102C, my lord. This is the final report on the basis of that first information report.
102.
102C.
Yes.
The
Type
brief
copy. Final report.
Final report, my lord. The brief story of the case is that on 11/5, my lord, it should have been 11/6. 11/6/2014, one Maruti car number so and so, Collins Wargery, which was proceeding from Barnihat side, dashed into a truck number so and so, driven by so and so, which was proceeding from opposite direction, as a result of which the driver of the Maruti car died on the spot and the only occupant of the car sustained minor injuries. Hence, a case by Nangpu UD case number so and so has been registered and duly investigated. During investigation, it was found that at the time of the accident, some police officers were detained by SCC Nangpo for Naka checking at the tri-junction by the NH40. While they were checking the suspected vehicle coming from Barnihat side, the said Maruti car was seen coming in excessive speed from the same direction. The driver of the car was given signal by the police to stop his vehicle, but instead he overtook the vehicle, which was being checked, and unable to control its speed, straightway dashed the said truck coming from the opposite direction, which then halted at its side after seeing the Maruti car coming towards it at excessive speed, and which has resulted in the accident and death of the driver of the Maruti car. The dead body of the driver was shifted.
You say that here this report says the driver of the vehicle of the car was given signal by the police to stop the
Yes.
vehicle, but instead he overtook the vehicle. Which vehicle?
Over in the same line, my lord, they were checking the vehicles. Now, when those vehicles were being checked, then this red color Maruti car was coming. The signal to stop. He did not stop. By overtaking this vehicle, which were being checked by the police, my lord, he came in a very speedy manner, in a rash and negligent way. Then he dashed the truck, which was standard in the opposite direction.
But here it says the truck was coming from opposite direction.
Yes, it was coming, possibly it was coming slowly, and since he was in a very negligent manner, he has given the speed and it dashed to the truck. And supposing it was coming slowly or whatever, if it was standard there also, well, the negligence is by this red color Maruti car, because first thing, it was his duty to obey the signal, to stop the vehicle, allow the police personnel to check up the vehicle. He did not do all this. He was in a drunken stage. He thought that if I stop it, the vehicle may be inspected. I am drunk. They may find so many things. So he wanted to escape from all this problematic part. So therefore this thing happened, and the negligence reached large, so far the deceased is concerned. And the final report is also made the thing very clear. Then, my lord, the dead body of the driver was shifted to CHC, Nangpo, CHC, that means civil hospital, by government vehicle for keeping the safe custody. Injured person and the driver of the truck were also taken to civil hospital, Nangpo, for medical examination. Both the vehicles were removed from the scene to clear traffic jam. Photographs of the place of occurrence could not be taken due to darkness. Dead body of the deceased, Collins Forgery, was handed over to the relatives after observing all the necessary formalities for performing the last rituals. Both the vehicle has been seized in the presence of the witnesses and released on Jimma, and after MBI report was received. During the course of investigation, the cause of death is found to be purely accidental and no foul play is suspected. Now, so far, section 174 of the CRPC, my lord, if there was any foul play, cognizable offence, then, my lord, the police will convert it into FIR and they will investigate that it's a murder case. But nothing of that sort. Final report is very clear that is purely accidental, no foul play is suspected. Now, thereafter, my lord, there is an order by the Chief Judicial Magistrate to make file an FIR against this and to conduct an inquiry. But then, when the wrongdoer is the deceased himself, the charge cannot be framed against the owner of the truck. So, therefore, ultimately nothing happened. It was closed in that manner. Now, I will take your lordships, I will cite those decisions I have already cited to your lordships, that your lordship may look at page 11 of the decision of Madhya Pradesh High Court.
Page?
हाँ, कॉपी मिल जाएगा. My lord, para 8 to 11. ये तो होगी.
Page 11 of what?
My lord, this is the decision I am referring. 2000 accident claim journal. At page 11, your lordship will find this decision. One set of decision I have handed over. दिया ना? 2000 SCJ 134. Amrata Shahu versus Ramadhar.
Amrata Shahu.
Amrata Shahu.
Ramadhar.
My lord.
2000
SCJ 134.
Yes.
My lord, I will read from
Para.
para 8 onwards. Mr. Rupra from there.
Yes.
Mr. Rupra, learned counsel for the insurance company, has urged before us that the insurance policy only covers risk in respect of death of or bodily injury, damage to any property of a third party, and not the insured himself. The learned counsel has specifically invited our attention to Section 147 of the Motor Vehicle Act and submitted that the term of policy is that it ensures, it insures, not ensures, this is a printing mistake, it insures the person or classes of persons specified in the policy to the extent specified in subsection 2 against any liability which may be incurred by him in respect of the death of or bodily injury to any person or damage to any property of a third party caused by or arising out of the use of the vehicle in a public place. Therefore, the learned counsel submits that as per section 147 of the Motor Vehicle Act, what is insured is third party and not the insured himself. The submission of the learned counsel appears to be justified. The basis of insurance is that if any liability arises, then the insurance company shall be liable to indemnify the third party on behalf of the insured. But in case when the insured himself meets with an accident and dies, then that risk is not covered by the insurance policy. Because whatever policy we take, this is in regard to the liability which incurred when accident occurs. Not myself, I am not been insured because that's the purview of my lord life insurance policy. Then paragraph 9. The learned counsel has also invited our attention to section 149 of the Motor Vehicle Act, which says that the insurer is only to satisfy the award against the vehicle insured in respect of third party risk. The learned counsel submits that by reading of both section 147 and 149, it is more than clear that the liability of insurance company is to compensate the insured towards the risk of third party and to satisfy the judgment and award passed against the insured. The submission of the learned counsel appears to be justified. The claims tribunal has labored under the impression that since it is a comprehensive policy, we may skip this para, my lord. Then your lordship may see para 11, that is important. On survey of the aforesaid decisions, it becomes more than apparent that the insurance company only insures the liability arising out of the insured and it does not insure the insured. In the present case, though the policy was a comprehensive policy, but it did not cover the insured as per section 147(1), it clearly transpires that a policy of insurance must be a policy which insures the person or classes of persons specified in the policy to the extent specified in subsection 2 against any liability. This is the important part. Subsection 2 against any liability which may be incurred by him in respect of the death or bodily injury to any person or damage to any property of third party caused by or arising out of the use of the vehicle in public place. Now, upshot of entire thing is that if the section 147 subclause 2 that has clarified that matter, if the person the insurance company insures the liability of the insured, that is the liability towards the third party, not the person himself. Then, my lord, I will take your lordships at another decision 2009. The next page your lordship will find in that folder.
Yes.
2009 13 SCC, page 710. I will rely on paragraph 24, 25 and 26.
Twenty-four, 25.
24, 25, 26. Your lordship may see the para 20 from 19, 20, 21 also. Paragraph 19 I will read, my lords. In Oriental Insurance Company Limited versus Rajni Devi, wherein one of us, namely Honorable S.B. Shinaje, was a party, it has been categorically held that in a case where third party is involved, the liability of the insurance company would be unlimited. It was also held in the said decision that where, however, compensation is claimed for the death of the owner or another passenger of the vehicle, the contract of insurance being governed by the contract, qua-contract, the claim of the claimant against the insurance company would depend upon terms of the thereof. It was held in Oriental Insurance Company Limited that Section 163A of the MB Act cannot be said to have any application in respect of an accident wherein the owner of the motor vehicle himself is involved. The decision further held that a question is no longer res integra. The liability under Section 163A of the MB Act is on the owner of the vehicle. So a person cannot be both a claimant as also a recipient with respect to claim. Therefore, the heirs of the deceased could not have maintained a claim in terms of Section 163A. In our considered opinion, the ratio of the decision in Oriental Insurance Company Limited is clearly applicable to the facts of the present case. In the present case, the deceased was not the owner of the motorbike in question. He borrowed the said motorbike from its real owner. The deceased cannot be held to be an employee of the owner of the motorbike, although he was authorized to drive the said vehicle by its owner, and therefore he would step into the shoes of the owner of the motorbike. We have already extracted section so and so, which a bare perusal of the said provision would make it explicitly clear that persons like the deceased in the present case would step into the shoes of the owner of the vehicle. Then your lordship may turn to paragraph 24, my lord. However, in the question remains as to whether an application for demand of compensation could have been made by the legal representative of the deceased as provided in section 166 of the Motor Vehicle Act. The said provision specifically provides that an application for compensation arising out of an accident of the nature specified in subsection 1 of section 165 may be made by the person who has sustained the injury or by the owner of the property, or where death has resulted from the accident by all or any of the legal representative of the deceased, or by any agent duly authorized by the person injured, or all or any of the legal representative of the deceased, as the case may be. When application of the aforesaid nature claiming compensation under the provision of section 166 is received, the tribunal is required to hold an inquiry into the claim and then proceed to make an award which, however, would be subject to the provision of section 162 by determining the amount of compensation which is found to be just. Person or persons who make claim for compensation would thereafter be paid such amount. When such a claim is made by the legal representative of the deceased, it has to be proved that the deceased was not himself responsible for the accident by his rash and negligent driving. This is very important. It would also be necessary to prove that the deceased would be covered under the policy so as to make the insurance company liable to make the payment to the heirs. Then paras 26, my lord, they have quoted section 147, and this is a very relevant thing. Now your lordship may see 147 clause B, as I have already read. Ensures the person or classes of persons specified in the policy to the extent specified in subsection 2 against any liability. This is very important, my lord. It is applicable in this case. Roman 1. Against any liability which may be incurred by him, that is by the owner, in respect of the death of or bodily injury to any person, including owner of the goods or his authorized representative carried in the vehicle, or damage to any property of a third party caused by or arising out of the use of the vehicle in a public place. Then your lordship may skip this judgment. Then, my lord, next decision is 2009 2 SCC, page 417. I'll rely para 15, 16 and 19.
Yes, no? Sadanand.
Yeah.
Yes.
Para 15, Your Lordship.
Yes.
See, keeping in view the aforementioned parliamentary object, let us consider the fact of the present case so as to consider as to whether insurer is liable to pay the amount of compensation in relation to the accident occurred by use of the vehicle which was being driven by the son of the insured. We may for the said purpose notice certain decision covering different categories of the claim in United versus so and so. Court considered the provision of the Motor Vehicle Act 1939 as also 1988 and inter alia opined that the insurance company would have no liability towards the injuries suffered by the deceased who was a pillion rider, as the insurance policy was statutory policy which did not cover the gratuitous passengers. Then paragraph 16. In Oriental Insurance versus Jhuma Shaha, it was held the deceased was the owner of the vehicle for the reasons stated in the claim petition or otherwise. He himself was to be blamed for the accident. The accident did not involve motor vehicle other than the one which he was driving. The question which arises for consideration is that the deceased himself being negligent, the claim petition under section 166 of the Motor Vehicle Act would be maintainable. Liability of the insurance company is to the extent of indemnification of the insured against the respondent or an injured person, a third person, or in respect of a damages of property. Thus, if the insured cannot be fastened with any liability under the provisions of the Motor Vehicle Act, the questions of the insurer being liable to indemnify the insured therefore does not arise. Now, these are the decisions, my lord, very explicitly settle the legal position, because a person who is himself negligent for his own driving, in that circumstances, my lord, he is not going to the legal representative are not entitled to get any compensation. The law is to that extent has been clarified by in all these decisions.
Yes.
Then the last decision by the Honorable Guwahati High Court, I will not read it, my lord, I will just leave for your lordships to see that. Here a question arose whether the vehicle was borrowed or not. Now the finding of the learned judge is that if we do not presume that he has borrowed, then he was an unauthorized person, he has stolen the vehicle. So that cannot happen. So a pragmatic idea should be taken up, or to assume that the vehicle was borrowed. Otherwise, if an unauthorized person driving, then it is like stealing a vehicle. In that case, the fact of the case will be more vast. So
It has to be presumed that it was borrowed.
Obviously, my lord.
Like you said earlier, you see, he steps into the shoes of
the owner, because his position will be akin to the position of the owner. Because what will happen to the owner if he drives the vehicle and he meets with an accident, something happens to him? So in that case, the liability of the insurance company is not there at all, because 147 had made it very clear, because the his liability of the owner is which is incurred by him, that is third party liability. If any other person dies, third party's property, in those circumstances only.
See, Mr. Datta, what I can understand is this. You're confining your argument only to the aspect of the vehicle,
my lord,
duly insured with you, being driven by a person, okay, let's put it this way, owner or not owner,
right,
which met with an accident, and his liability vis-a-vis the policy condition as far as you're concerned. So to that extent I can understand.
Yes.
But I think in this case it is not so. See, because the liability is said to be caused by the other vehicle.
My lord, here the negligent vehicle is from the eyewitnesses is very clear.
No, that is true. That aspect is correct.
So that
your proposition is correct.
Yes.
See, we put it, your proposition is correct.
My lord.
But you have to counter the argument of the appellant or the claimant that the accident was caused due to the rash and negligent driving of the driver of the truck,
Lord,
which
yes,
vehicle was insured with you.
my lord. But then the answer to that is, my lord, where is the evidence?
True.
There is no evidence at all.
That's true.
Now the eyewitnesses have clarified the matter because they were the person who were doing duty of Naka checking. They stopped the vehicle for checking up. He did not obey the signal. Then he, in a rash and negligent manner, he drove the vehicle. He hit the truck. So, my lord, whatever my learned friend argued, that the other vehicle is the truck, that is with the New India Assurance Company. So, if you want to make a case that because of the fault of that vehicle, he died, in that case he is having a case. But then there is no such evidence to that extent.
But that is his stand.
Yes, yes, I could understand.
That is the stand of the appellant.
Right, right.
So what you are trying to argue would makes no difference.
Right.
As far as this, because the court will not go into that.
Yes.
Whether because you are the driver of the vehicle which was involved in the accident,
My lord.
and you died out of the because of the accident.
My lord.
Let's put it this way: your fault, not your fault.
Exactly.
Even if it is your fault, not your fault, the insurer of that vehicle driven by him is not liable.
Yes, yes.
That is, I think that is understood.
Yes, my interpretation up to that only, my lord.
Yes, that's all.
And I think I've been able to persuade your lordship to that extent.
We can accept that. He will also accept that.
Yes, yes.
Because the grounds made out are otherwise.
Yes.
Like I said, again repeating myself, it is to fasten liability on the owner and driver of the truck.
Very correct.
That's all.
Now so far Mr. Jindal is concerned, he tried his best, but then since there is no evidence, and I don't think he can succeed.
Whether I will succeed or I will not.
that of course the honorable court is there to adjudicate. So,
Should I please?
my lord, I have made a written argument also to facilitate your lordships. आप भी रख लीजिए, एक थोड़ा साइन कर दीजिए ना. My lord, it will assist, this written argument will assist your lordship because in a very chronological manner I have made it. और कुछ है कि बोलेगा?
ड्राइवर को बोलने दो. वो क्या बोलता
क्या चीज़? ड्राइवर बोलेंगे. The finding of the learned judge, your lordship has seen already, so I am not going to that. बोलना है कुछ?
I will counter you.
हाँ ठीक है, बोलिए.
5 मिनट
So
लगेगा.
let my learned friend will say something.
No, whether
हाँ वो दे रहे हैं.
you want to say something or you will adopt.
I have limited
Yes,
point
please come.
submissions, Lordship, here in this case.
Come here.
See, Mr. D,
Lordship.
you first have to state your case as to what is your locus at this point of time.
Yes, Lordship. Yes, I'm coming.
The fact being that you have already been excluded from the proceedings
Yes.
before the tribunal.
Tribunal. Yes.
So now all of a sudden, from where did you pop up?
No. In the trial court tribunal, Lordship, I have not received any notice, Lordship. First time when the appeal has been preferred before this Honorable High Court, when they issued the notice, only then I received a notice. And being a law-abiding citizen, Lordship, I appeared before this Honorable High Court. Lordship.
You should have filed cross appeal.
No, because
The fact that you have not received notice,
no,
so you are excluded from the proceedings.
yes,
There are certain stands, or rather the stand that is to be made by you, could not be articulated by you before the tribunal.
yes,
But that defense was taken over by the insurance company. So, in effect, you see, whether you do it yourself or somebody does it for you, your defense has already been taken.
yes, Lordship.
What do you have to say to that? You see, the only thing is that now
No.
your contention or your stand would be against the insurance company now. Why have they taken over your defense when you are supposed to take it yourself. So that will have to be decided. But you have not raised this issue.
No.
That has to be raised in a cross appeal.
Because
So now, I don't know, at this point of time,
no, Lordship, I'm only the mere driver, Lordship.
you may,
That is the
see, we are not talking, now we are not on merits. We have not proceeded to that. See, we have proceeded, we are now, this court is just to ensure whether you can be allowed to, to state your case or not.
No, whatever I have gone through and whatever the driver has told me, they're similar to the facts.
You're going to the,
that's his
going
message.
into the factual,
Otherwise,
the merits.
I whatever my senior in behalf of insurance, I adopt this.
Okay, no problem.
He has not said anything about it.
No. But the
Because he's precluded from that.
Yes,
from
yes.
saying so, because you are present now.
Yes.
It's a very tricky situation.
Yes, Lordship.
I'll just give a short reply.
First, you have to solve this issue, Mr.
This is actually not, I have already sorted out. And because the
You have not- then why-
tribunal has passed the ex parte order,
Then why?
not following the procedure. It's not that. Court has taken all things into consideration, and later on it was published in the paper by the order of the court. And whether he has read the newspaper or not newspaper, we cannot say. But according to law, what we were supposed to do, we have done it. And now, in the appellate stage, since he was made a party in the tribunal, I have also made him a formal party, because the reason is this, Your Lordship, that insurance company has already taken over the defense.
Exactly.
Taken over the defense. Even if he comes here, if he says that insurance company has taken over my defense, and whatever he has stated, I adopt matter ends there.
True.
Matter ends.
That's true. But in
case he wants to have a different stand.
In that case, then Mr. Datta has to be given the opportunity to defend, to submit.
That he has already submitted.
To submit on behalf of the driver.
Driver
He has not said anything about it.
No.
As far as the driver is concerned, driver of the truck is
Your Lordship, he is telling that accident was caused not due to the fault of the driver, his driver. But it was caused because of the negligence of the deceased driver.
That can be presumed then.
And that is what is required here. Whether findings of the court is correct or not here.
Oh, so that is we are only because that again I am saying, this is it doesn't happen like this.
It never happened. It never happened, at least during my doing the MBCT cases. It never happened. And I have never come across also any case where the claim of the claimants are dismissed on the ground of negligence when there are evidence. Normally, Your Lordship, once the death and the accidents are admitted and there is no defense in the policy, and so much so, he has not come before the tribunal by producing the insurance policy, that under these terms and condition of the policy, we are not liable. He has not produced that.
He is not, you see, he is not denying the fact that policy is not valid.
It's
valid.
Yes, but terms and condition.
Terms and condition.
Terms and condition of the policy under which he wants to escape the liability are not produced. And no person from the insurance company is examined that to say that our company is not liable. So, Your Lordship, so far my friend is concerned.
So, Mr. Day, what do we do? You will adopt his...
Yes, I'm just what I submitted, Lordship.
Okay, I'll note that down and then we'll see.
Yes. Lordship, only 2-3 points I would like to clarify. Your Lordship, the first point which my learned friend has raised, that petition under section 170 is not required, was not required, and if I have made a party in my claim petition, he has a right. He has a right to defend it on all the ground, provided they are not there. They are not there, and matter is being proceeded ex parte against them. Now, I don't dispute this proposition, but point is this: if it was not required, why it was filed under section 170? Petition I have already shown. Petition was filed, meaning thereby they have specifically taken over the defense of the owner and insured. Though there is no specific order, but the insurance company was allowed to lead evidence on all the points, and they did it so. So, whether petition was required, petition according to me was not required, but still they filed. And if a petition is filed, there has to be an order on that petition. Order was not passed. That's why in memo of appeal, I have taken this defense that if the petition would not have filed, there was no question of passing any order.
Whatever the case may be, passing of the order or not passing of the order, the tribunal has allowed him to take on the defense of the
Yes. Also, the matter that's why I did not argue much on that point. In fact, I have conceded that point by not arguing that point.
Okay.
Now, Your Lordship, what surprised me today most is this, that my learned friend has advanced his argument, presuming that he is the insured of Maruti car. His entire argument is this. He is referring to section 147. He is citing judgments which are relating to the Maruti car. And he is not the insurer of the Maruti car. He is the insurer of the truck. About truck he doesn't say anything, and that how truck is not liable under section 147, that third party liability. I am third party in relation to the truck, and I am claiming compensation as a third party from the truck, which he has not argued. He has not even disputed that fact, either in the written statement or the submissions made by him before the court. He says that he is going on the Maruti car, that the deceased driver step into the shoes of the deceased driver of the Maruti car. And under section 147, the liability is not covered. He is not the insurer. I really got shocked to hear my learned friends arguing on the Maruti car insurance and referring section 147, keeping quiet about the involvement of his truck or liability of his truck, that his insured is not liable. This is, Your Lordship, a surprising picture which my learned friend has argued today, that to divert the attention of this court to of course this court itself has pointed out to him that whether you are arguing for as an insurer of the Maruti car or of truck. He is arguing as an insurer of the Maruti car, not as an insurer of the truck, which is highly improper. Then, Your Lordship, he has referred to the evidence of OPW 2 and 3. Your Lordship, on the last OP number 2 and 3 says that truck was stationary. The IO who has filed the final report, in his report and in his evidence, he states that the truck was moving. CW2 and CW4 have stated that the truck was coming from the opposite direction, and it tried to overtook the other vehicle and dashed the Lordship. Now, one point, Your Lordship, which he has argued that both the driver and the co-passenger were drunk. He has referred only to the copy of this postmortem report. This postmortem report, Your Lordship, first thing that it is original postmortem report is not produced. Second thing, the doctor is not examined who has done the postmortem. Thirdly, Your Lordship, the impugned judgment, there is nothing mentioned that the cause of the accident was the drunkenness of the driver of the Maruti car. There is nothing that the court below has recorded, Your Lordship. Assuming but not even considering that there was some smell of alcohol and indigest food. The law is also very clear, Your Lordship, that the time and at which the drink was taken and the quantity of drink and percentage of alcohol found in the blood. A person, if he take a person may take half a peg or one peg, and he is still in a better position to drive the vehicle, and there may be a person who has taken 5-6 pegs and driving the vehicle. Then it has to be a certain what percentage of blood, of what percentage of alcohol is found in the blood of the disease. There is no such report of any forensic laboratory certifying that the disease driver was having so much percentage of alcohol in the blood. Nothing sort of that, Your Lordship. And in that connection, Your Lordship, I'll just cite one judgment. This is Madras High Court. Your Lordship will see, come page number 14, paragraph 14 and 15. Last time. Paragraph 14 and 15. Moreover, Lordship got it. Yes. Moreover, it is specific case of the respondent that the disease was under intoxications. The learned counsel for the respondent has relied on the report issued by the forensic laboratory that the blood collected from the disease was detected 76 milligram percent weight by volume of ethyl/alcohol. In India, if the amount of alcohol is more than 30 milligram per 100 milliliter of blood, the person is considered drunk, driving or driving under the influence. So, unless this evidence is brought before the court, a simple fact that some smell of alcohol is found is not sufficient to dislodge the claimant to claim compensation, Your Lordship. Because that what is found is only the smell of alcohol. At what he was coming from Guwahati side, at what time he took, and the law is made specific that in India, if the amount of alcohol is more than 30 mg per 100 milliliter of blood, if this evidence comes, then the person deemed to be a drunken driver, otherwise not. because some people are there who may be better in a position to stand even after taking 5 packs. There may be a person like me, even with a half a pack, I may be down. So percentage, Your Lordship, is most essential. And that's why the Learned Tribunal has not based his conclusion on the ground that the disease was found to be a drunken driver. To return this finding, there has to be concrete evidence of the forensic laboratory that the quantity of blood was 30 mg per 100 milliliter of the blood collection. In absence of, they have not examined the doctor. Original report is not produced. Why they could not bring the doctor who conducted the postmortem, so that their position would have been clear that whether by getting the smell person can said to be a drunken driver? My humble submission is this, Your Lordship, it is not. Now, Your Lordship, even if Your Lordship feels that why there should be a smell, I have already stated in the before the tribunal that if this tribunal feels, they may deduct 10%, 15% from the compensation, and that will be balancing the justice.
Where's the basis for that?
Basis? There is no basis. There is no.
If that is the case, if that is your argument, then it would, it would strengthen the presumption that he was.
No, Your Lordship. This is actually not my submission. I'm telling the basis. There is no basis, in fact.
Perhaps we take the post-mortem and as well as the report. I mean, the evidence of the OPWs that he was drunk. But the only thing, as you have said, only the level is not known. Whether it's permissible, not permissible.
It's actually not permissible. And if Your Lordship goes strictly in accordance with the law and in accordance with the evidence, now, so far the co-passenger is concerned, he has got nothing to do with the accident. Another thing, where is the evidence of that co-accused was, the co-passengers were drunk? Simply because one policeman says that he was, how could he say that he was drunk? He was neither a doctor nor he did any smell test. They used to carry one instrument by which.
Have you
instrument? They have not done that. At least by that they can say.
Have you produced him as a witness before the tribunal?
Who?
This co-passenger?
Co-passenger, Your Lordship, yes, he is CW2. He is CW2. And he said that accident took place because of the.
There was nothing in the cross
no question is put to him.
That he was drunk or something.
No question was put to him. Suddenly it came from the police person. And the police person, IO, has stated that these two other police person who said to be eyewitness, they have told him that the truck was parked. The truck was parked. And the truck was moving. No, in the court they say different thing. And I have, on the last occasion, I have also pointed out that there are 4 theories which they have tried to introduce in this case. Whether the truck was moving or stationary, or it stopped, or it overtook or not, Your Lordship. And moreover, Your Lordship will find that 11 years have passed, Your Lordship. And more than a decade, the family is struggling hard.
How can you say struggling hard? They have survived for 1 decade.
They have
They can
survived.
survive for another
You see,
3 decades.
survival should be of a human nature, not inhuman nature.
You know the principle of compensation as far as motor accident claims are concerned should not be a windfall.
Yes, Your Lordship is. So, Your Lordship will decide, and if Your Lordship find that I have made out a case, then instead of again sending me back to the base, I would request this Honorable Court.
11 years means there's no scope for sending it back. It will be decided here one way or the other. The only thing is, it will not go down, it might go up. That's all.
No problem is this, Your Lordship. At one judgment, Your Lordship, that you give me the list of this one, 1988 authorisation. Your Lordship will take one judgment, 1988 4 SCC 163. You have a second copy?
कितना बोलते हैं? टाइम भी हो गया ना?
हो गया बस. मैं finished. इनको 2 मिनट दे. You have disappointed me. Your Lordship, just I'll read paragraph 12 and 13.
क्या 12, 13.
Remand पे. Paragraph 12 and 13. We can very well appreciate.
You have given him all copies of it?
No, that list of judgments I have given him. List of judgments I have given him. We can very well appreciate the anxiety and need of claimants to get compensation here and now, no matter what it is. The lands were acquired as far back in 1977. 1 decade has already passed. Now the remand means another round of litigation. Then I escape the in between lines and come to the appellate power. Lordship got it?
Yes.
The appellate power of the remand at any rate ought not to be exercised lightly. It shall not be restored to unless the award is wholly unintelligible. It shall not be exercised unless there is a total lack of evidence. If remand is imperative and if the claim for enhanced compensation is tenable, it would be proper for the appellate court to do modest best to mitigate hardship. The appellate court may direct some interim payment to the claimant subject to adjustment in the eventual award. Counsel for the state argued that there is no material on record for this court to determine compensation, and the remand may be useful for the claimant themselves. We, however, reluctantly indicated his own estimate of the market value in the event of this court giving a quietus to the litigation, Your Lordship. So, Your Lordship, in this case, there are sufficient evidence to determine the quantum because he was a government servant. Service book is a part of the paper book and it was exhibited in the trial court. The question and the law is well settled how to compute the income multiplier and future loss. It's a well settled. So my humble submission, Your Lordship, will be subject to Your Lordship deciding the appeal. In my memo of appeal also, I have made this prayer. If Your Lordship see my prayer in the memo of appeal, हो गया बस In the premises, it is therefore prayed that your Lordship would be graciously pleased to admit the appeal and call for the records of the MSc case number so and so. Issue notice to the respondent upon hearing both the parties be further pleased to set aside, modified the impugned judgment and order dated 6/12 passed by MSc Shillong in MSc case number. Decide the issue number 2, 3 and 4 relating to award of compensation and interest to the appellant claimant instead of remanding the matter back to the tribunal after more than a decade. So I have made your Lordship.
Yes, Mr. Jindal, sorry to interrupt you. I have forgotten what you have submitted in the earlier round, but have you touched on this area of computation of the award?
No, that your Lordship will give an opportunity. Because my appeal is not, since it was not decided by the trial court.
No, you see, you cannot do that. You see, now firstly you have come against a decision where the tribunal has said that the cause of the accident was due to your negligence.
Yes.
So no award.
No award.
Okay. If you see now, actually, what you should do before this court, with the appellate court, is this: considering your prayer that it should not be remanded back for fresh consideration, if at all. See, we are going on supposition now.
Yes, supposition only.
So you should alternatively make a separate argument as far as computation of the.
Yes, if your Lordship give me an opportunity.
In that case, you see, they will refute it.
Yes.
And if
your Lordship may.
On the first count, if the court decides that yes, you are liable.
If your Lordship fix a date for allowing us.
I skipped my mind also until you brought it to knowledge of this court. That should have been a comprehensive, argument on your part.
No, your Lordship, that is true, your Lordship. In the last occasion also, I wanted to raise this point. My learned friends objected to it.
Mr. Dutta, what do you say about this?
Beg your pardon.
What do you say about this?
Regarding the computation. That will come subject to the condition that the evidence supports him.
No, yes, no, we are not on that. We are not on that. This appeal has been taken on board. Like I said again, just now, I am just repeating myself. If he succeeds,
yes,
then the issue of computation will come.
Yeah, in that context, your Lordship is saying.
This court will not go into that. You see,
right.
Because you may have your computation may be different, yours may be different. Findings of the court will be different.
Yes.
So the court will not, venture into that area. It is for you, for the appellant, to come before the court and make this is our computation, multiplier, interest, whatever, and for you to oppose that, or say that if he has, suppose we just again going on, suppose if he has come finally to a computation of 10 lakhs, you see, not 10 lakhs, should be 1 lakh. The court will decide yes, 1 lakh, 10 lakh, whatever, but basis has to be there. So for that, I have to hear the parties.
Yes, Lordship. That's what
we'll continue here. I'll not dispose of this and then start afresh.
All right.
That will not serve the purpose.
Yes.
Should have done that.
Because
he knows, my lord, he doesn't have any case. No. So therefore he refrained from doing that.
that your Lordship.
You see, this is what they call abundant precaution.
Yes. So your Lordship is very right. Supposing this honourable court is required to adjudicate the matter and you want this much of amount, he should have highlighted that.
Yeah.
No, your Lordship, that is true, your Lordship. I have, even in my memo of appeal, I have made a prayer.
You have prayed.
Made a prayer.
But you have to substantiate your prayer.
That actually prayer comes when your Lordship passes an order that pending disposal of the issue. Or
the court will not even venture to the question of interim relief, not at this stage.
Yes. Right. So then we argue on.
He's a veteran.
We argue.
Jindal is very veteran. He knows what is his case.
Section 140 is still prevalent.
That's why 147 is using against my vehicle.
No, 140 के बाद बोल रहे हैं.
140 50,000 दे के रखा है ऐसे.
Not revise.
That earlier, because it's 10-year-old course, that time it was 50,000 only. No, it is 5 lakh.
5 lakhs? Now?
Now.
Okay.
It's 5 lakh now.
Yeah, I don't know. That's what I'm another new act.
It is there in the amendment.
Yes,
It is there in the amendment, but problem of claiming that is one of the judgment of the Supreme Court says that if you claim interim relief for 5 lakhs, matter ends. You loses your right to right to claim. So that's why some lawyers, they have filed the claim application claiming 5 lakhs.
You could have.
We have not objected. We have not objected.
You should have done that because the no fault liability is there.
And no
That
fault
would have
liability.
been better option.
No fault liability. At the relevant time, it was 50,000, but there was no bar. Now this 5 lakhs is as good as 163A. There used to be 163A.
Schedule 2.
So there also claimants were benefited because it was according to the multiplier, according to the multiplier system. But now it is risky to claim interim relief of 5 lakhs because if you claim 5 lakhs, insurance company will take the ground that matter ends here. Then Supreme Court also says that that if you have accepted 5 lakhs, matter ends. And here in this case, your lordship, 11-year interest they have to pay. 11-year and in such cases, your lordship, where the matter was dragged, if your lordship see the order sheet, how many adjournment they have taken.
In your next round of argument, you reach those points.
I'm just...
when do we fix it?
My lord, any day my learned friend will appear in the next time, my lord.
Mr. General?
I'm free.
2 weeks time then?
5 लाख ले लो, खत्म कर दो. कितना केस करता है?
अरे मैं कहाँ करता हूँ, मेरे पास खत्म हो गया सब.
Fix it on 12th.
1st August.
12, 12.
Sir, we will forget. 12 is I'm
He started the case for how many years? 15 years.
5th August.
5th, my lord. 5th.
You say he will come?
12.
No, you are coming. You are coming.
No, subject to the condition if time permits. कितना बोला आप? 11 करो. 11th August में.
11th August. No, 11th August हो जाएगा. 11th August.
Mr.
I'll confine only on the compensation.
Yes, of course. Mr. Datta Leonard Senior Counsel, along with Mr. S.D. Upadhyay, has made his submission on behalf of the respondent insurance company, and the same was concluded. Mr. P.D. and I counsel for the respondent number 2. Driver has also concluded his submission. Mr. General, in his reply, has submitted that he may be allowed to continue his argument on other aspects of the matter on the next date. As agreed to by the parties, this is matter for further hearing on 11th.
Published.
Item number 6.
That was passed over, so it will come.
Good afternoon. Lordship, I filed a bail application, it was moved. Thereafter, an objection was filed. I filed my rejoinder. Perhaps, Your Lordship, it would be nice if, because I've already highlighted the points under which I've sought bail. So it would be appropriate, I believe, if the objections are put up so that I can rebut. There would just be a multiplicity. I would submit, he would submit, I would submit again. I will, but after your, no, first, but if you start, so just be multiplicity.
Yes, Mr. Sankar.
My lord, the bail application which my learned friend has filed, my lord, this is as regard to the offence under UAPA Act, under section 10, 13, 18 of the UAPA Act, and also section 120B, 121A IPC, along with section 5 and 6 of the Explosive Substance Act, my lord. Now, my lord, as far as section 18 is concerned, this is section 18 of the UAPA Act deals. This falls under chapter 4 of the Act. In terms of section 43D, my lord, there is a clear bar for granting of bail. If I can just read out the appropriate provision, my lord.
You are first on 43D.
Yes, my lord.
Mr. Yadav, you can sit.
My lord, section 43D, subsection 2, my lord, yeah,
By the way,
My lord.
sorry, Mr. Sankar,
my lord.
sorry to interrupt you. I'll take up Mr. Yobin's matter first.
My lord.
I forgot just now because that I think that is only on the issue of mediation, isn't it? Call into that.
Second call, item number 2.
My lord, the government has also requested for sending mediation. I am also agreeable to that, my lord, because I found it's not going to affect Mr. Paul's senior counsel Rakhi's client. Why? Because if in the under the general seat, general reservation, nobody was given appointment in this particular recruitment. So now, even if we two gets absorbed into our respective categories and they get pushed up also, it's not going to affect anybody's case.
What about vacancies?
Vacancies are there, my lord. Vacancies are there.
Let it be
They are
sent
not
to
affected by
mediation.
that.
Let the
They are not affected by that.
They're not going to be
That is
affected
my
in
friend
any
is
which
saying.
way.
As far as this slot is concerned,
Yes.
My lord, this matter pertains to reservation, my lord. The entire case is based on the reservation policy. So, my lord, my humble submission, this matter may not be.
no, you see, it's not as simple as that. See,
Yes.
It's not a question of reservation. It's a question of what should we say? Put it this way: question of identifying whether they fall under the category of SC or ST.
We don't
Or
know also
you
the
are.
whether any vacancy.
My lord, they will be
there or
present
not.
in the mediation, my lord.
Yes.
So it is not that something like I and Mr. Yobin only will be there and will be deciding behind their back. So we can give a try, my lord, because the petitioner himself is also felt that something can be accommodated to
Finally,
him.
the onus will be on the government.
Exactly, my lord.
But how they decide, is
Yes,
up
my
to
lord.
them.
So if it will be better, my lord, it will be the best in the interest of both the parties if it can be resolved. So we can have a try, my lord.
You can take part in the.
They will be. They are part of the writ, my lord. They
and
will be
see
party.
If matter
Notice
is
will
not
be issued to
resolved,
them.
then not
Yes,
resolved.
come back.
My
Come
lord.
back.
Otherwise,
Yes,
my
my
lord,
lord.
my appointment is on merits, my lord.
That is okay. I think
Yes.
have you challenged your appointment?
No, I've not even challenged their appointment. I was only saying that you have clubbed together and you have left us, you have given us the clubbing. Now, the law says that if your merit list, you have scored more than the cutoff of the general, you can get in general also. And in this case, nobody from the general, I don't know whatever reason, nobody was appointed.
Then we'll see.
Yes,
My
yes,
lord,
my lord.
If you
let's
are
have a
able
try,
to
my lord.
mediation,
Yes.
we'll
We
see.
can try, my
My
lord.
lord.
learned counsel for the parties are present. I am Mr. P. Yobin, learned counsel for the petitioner, Ms. P. Kulni, R. Kulni, learned J. appearing for the state respondent 124, and Ms. R. Dr. learned counsel appearing for respondent 5 have jointly submitted at the bar that this matter may be referred for mediation to allow the parties to make an effort to settle the matter therein.
Yes, ma'am.
Accordingly, matter is referred for mediation. Formal order will follow.
My lord.
Formal notice will follow.
My lord.
7 of them left the job also. So there's, to my knowledge, also 7 vacancies are there. After selected, they left.
In mediation, you can do that.
Yes.
See, in mediation,
It is their
everything
duty
can
to
be
place
settled.
that.
Yes, my lord.
Let them place that.
Yes,
Our
my lord.
department also will place what is there.
All right.
Item number 6.
Mr. Kanta, what about your matter?
My matter, I'm ready to argue.
You're ready. What about the other side? Oh, Dr. Musika is there. Yes,
Your
not a
Lordship.
bill.
No, Your Lordship, it's going to take some time, Your Lordship.
What do we do? Instead of making you wait, we'll fix another date. Or if you're willing to wait,
Lordship, I
because
have a suggestion.
if he's on legs, then nothing can be done.
Admittedly, he's on his leg. If it can be posted tomorrow or on Friday, Your Lordship.
Friday, Your Lordship.
Friday?
Tomorrow, Your Lordship, because I have spoken to her senior.
Your Lordship, tomorrow is also fine.
Kato ka number yung to? Boy. As agreed to by the parties, this is matter tomorrow.
As a first item, Your Lordship, because it was already there as a first item.
But I think the questions drawn up, can you supplement?
Come in supplementary.
Yeah, it'll come in supplementary, so we'll take up supplementary list first.
Much obliged.
Item number 6.
Next, if I can start my my lord, what I was submitting is, my lord, because
43D.
this is the UAPA Act, section 43D, clause 5, my lord. Now, my lord, clause 5, it says, notwithstanding anything contained in the code, no person accused of an offence punishable under chapter 4 and 6 of this act shall, if in custody, be released on bail or on his own bond, unless the public prosecutor has been given an opportunity of being heard on the application for such release, provided that such accused person shall not be released on bail or on his own bond if the court, on a perusal of the case diary or the report made under section 173 of the code, is of opinion that there are reasonable ground for believing that the accusation against such person is a prima facie true. If the allegations against the accused person is prima facie found to be true from the record, my lord, then there is no question of granting bail as far as section 43D is concerned, my lord. Now I would like to take your lordship to the bail applications, wherein, my lord, a copy of the charge sheet has been enclosed. It starts from page number 33, my lord. Here at page number 34, my lord will see at the below, my lord, particulars of person charge sheeted A2, last portion of page number 34, below. Particulars of person charge sheeted A2.
Yes.
Name of the accused is Robinus Ripner, for whom this instant bail application has been preferred, my lord. He has been charge sheeted along with other co-accused also, my lord, those who are not before this court, so we are not concerned about them, my lord. Now, if my lord will come to the copy of the FIR, my lord, that is at page number 12. I'll just take your lordship through the FIR, my lord. This is FIR dated 11/3/2024. My lord, the FIR reads as follows, my lord. There was an IED blast at Syndicate Bus Stand, Punjabi Lane, Shillong at around 22:30 hours on 9/3/2024. An FIR White Sardar PS case number 83/2024 under section 120B, 121A, 307, 324 IPC read with section 10, 13, 16, 18 of the UAPA Act and under section 3AB 5 and 6 of the Explosive Substance Act was registered in this regard, and Assis IPS so and so Shillong is the IO of the case. There is a strong reason to believe that the HNLC, which is an armed terrorist gang engaged in threatening and extorting individual with motive to challenge the sovereignty of India, has issued threat of bomb blast in the region, is involved in the blast and is planning to carry out more ID blast in Shillong and other parts of state. On the basis of interrogation details of the accused persons in the case, I was informed by the IO of the case that one Sri Damanbha Ripanar using phone number so and so along with Robinus Ripanar, who is the petitioner, my lord, in this case, using phone number so and so are highly suspected in this case, and he directed me to apprehend the said person. Based on tower location of the above mentioned person, I along with a team of SOT Shillong pursued him and finally located Sri Damanbha Ripnar alias Shal Lapang in vehicle bearing registration number so and so Bolero pickup at Umsning Mawhati Road near Meghalaya Agrovet Private Limited. In the meanwhile, a team of Ribhoi police led by Sri B. Zerua, additional SP, Ribhoi district, Nongpo, joined us. Upon interception, he revealed that he was carrying IED in his vehicle, which he intended to cause an explosion at a grocery shop near Rani Motors, Downgate, Nongpo on the evening of 10/3/2024. However, he could not carry out the explosion and was planning to do it again. Immediately afterwards, I informed my senior, who deputed bomb detection and disposal squad team to the PO. Upon arrival at the PO at Umsning Mawhati Road, the bomb detection and disposal squad confirmed the presence of explosive in the car bearing registration number so and so, and accordingly the above vehicle and the IED, which has been disassembled by the disposal squad team, was later seized by the Ribhoi police after getting clearance from the bomb detection and disposal squad team. In the meanwhile, another accused person, Sri Robinus Ripanar, was also apprehended from outside Bameri Resort, Umta village under Nongpo police station, Ribhoi district, in connection with the incident case by a team from Ribhoi district. So this is the, my lord, FIR, the contents of the FIR. And my lord, after investigations was done, my lord, the charge sheet was filed. The charge sheet, my lord, is at page number 33. And as I have already pointed out, my lord, page number 33, which says particulars of person charge sheeted, and the present applicant herein, my lord, who is the wife of the accused person, A2. Now, my lord, if my lord will see the copy of the charge sheet, my lord, may kindly come to page number 41. Page number 41.
Yes.
These are the past incident, my lord, which has been caused by the same group of unlawful association, my lord, that is HNLC. First incidents, my lord will see at number 1, IED blast at Star Cement, East Jaintia Hills District, Meghalaya, on 12 December 2020. IED blast at Police Bazar, Cleriat, on 14 July 2021. Low intensity IED blast in Laitumkhra, Shillong, on 10th August 2020.
Police reserve Cleriat.
Lamkhra, and one is Police Reserve Cleriat, my lord.
You see Police Bazar.
My lord, I am sorry, my lord. I stand corrected. Now, my lord, 4, it says bomb found outside NPP office, Shillong, on 4th October 2021. Then 5th, powerful bomb blast, Rock Police Bazar, on January 2022. Then again on 6th, my lord, that is IED blast at Harijan Colony, Barabazar, Shillong, on 9th March 2024. At below, my lord, it says, it is to be noted here that the banned Hinotrap National Liberation Council had claimed the responsibility of the above noted incident, which had occurred in different parts of the
Khasi and Jaintia Hills region. Whereas the publicity secretary of the band outfit HNLC Senkupar Nongtrao on 14th August 2021 had posted a message in the Highland Post where he claimed that they have created sleeper cells and will soon awaken them. They will not stop terrorizing until they achieve independence for the Jat Bindu. Now here, my lord, for page number 43, it repeats the story of the prosecution, my lord. Now, how the investigation has been conducted, I'll just take your lordship through this, my lord. During receipt of information, page number 43, my lord.
Page number 43.
It says, my lord, during the course of inquiry, credible information was received on 11th March 2024 at around 4 p.m. that a suspected HNLC cadre by the name A1, Damanbha Ripanar, was traveling in a vehicle bearing registration number so-and-so and was carrying an ID in the vehicle to carry out an explosion. On receipt of the information, a team of police SOT from Shillong, led by PW1 Inspector Simsang A. Sangma, in charge Special Cell Shillong, were detailed for duty in order to nab the said suspect. And accordingly, at around 5 p.m., information was received from PW2 to K. Pachwa of SOT Shillong that the suspect was detained by the Special Operation Team at Umsning Mauhati Road near Meghalaya Agrovet Private Limited. Next page, my lord, it says, it is to be noted here that on receipt of the credible information regarding suspect A1 Damanbha Ripnar, who was traveling in a vehicle bearing registration number so-and-so and was carrying ID to carry out an explosion, the said information was duly passed to the officer in charge so-and-so for making an entry into general GD entry for taking necessary actions. The reference to so-and-so. Now visit at the PO. Place of occurrence was visited, which is found to be located at Umsning Mauhati Road near Meghalaya Agrovet Private Limited and is about 10 km from the PS. It says, my lord, A1 Damanbha Ripanar, another person was also found seated in the passenger seat who identified himself as A3 Lamprang Marsing. Preliminary examinations. On being examined, A1 Damanbha Ripanar confessed to his role as being member of the band HNLC and that he had been entrusted by one person by the name Sanbor to carry out an explosion at a grocery store near Rani Motors, Downgate, Nongpo on the evening of 10/3/2024, but he could not carry out the task. Further, he voluntarily admitted to the carrying the IED which he had kept in the vehicle, and he was willing to lead the police team to show and identify the place where he had kept it. Now, my lord, may kindly see the relevant portion, page number 45. At around 6:30 p.m., under proper photography and videography, AI Sri Damanbha Ripanar voluntarily led the police team, and his statement was recorded under Section 27I Indian Evidence Act in presence of witnesses and showed the place where he had kept the IED. The IED was kept in a red carry bag labeled Maharaja Sana, which was kept under the driver's seat. The bomb detection and disposal squad team took out the carry bag and placed it on the ground nearby. They took out the content, which was red paper carton box labeled Exide dried, wrapped under the coconut rope with a fuse wire extending from inside the carton box. The BDDS team opened all the content of the carton box and laid it on the ground. The content included gelatin stick 15 numbers, detonator 3 numbers, splinters, iron rod cut into small cubes approximate 167 numbers, igniter fuse commercial 1 number 6 feet approximate, bunch of coconut rope weighing 200 grams approximate, cement bag of star cement. Now, my lord, will see page number 46. Those ID which were found, my lord, that has been already disposed. As per the SOP, the detonator were diffused in situ by the bomb disposal units and accordingly obtained the explosive ordnance disposal certificate from so-and-so. Now, my lord, will see the same page number 46 below, where it says examination of A1 Damanbha Ripanar. During further examination of A1, Sri Damanbha Ripnar, son of so-and-so, and Sri Abison Lapang, resident of so-and-so, reveal the identity of other member of sleeper cell who are his accomplice, namely A2 Sri Robinus Ripnar, for whom the bail application has been filed, my lord. Now, page number 47, my lord, it shows seizure entry. During the course of investigation, the below noted article from the possession of A1 and Sri Abhishan Lapang.
We are reading?
Page number 47, my lord.
Yes.
Seizure entry.
Seizure entry.
Yes. Now, from A1, my lord, Damanbha Ripnar, one dark blue Oppo smartphone bearing number so and so was seized, along with one Mahindra pickup where the ID was kept. Now, my lord, may kindly see in the same page, during investigation, A2 Sri Robinus Ripnar, 37 years, so and so, was produced to Nongpo PS, who was accordingly interrogated, where he admitted to his involvement with the instant case, and accordingly he was arrested in connection with this instant case. Now, from him also, my lord, some of the articles that were seized, that is one phone, and one Hero 600 normal phone bearing number so and so. Now, my lord, may kindly come to page number 50. Page number 50, on top, my lord, it says A2 Sri Robinus Ripnar.
Yes.
It says, my lord, Robinus Ripnar revealed that he is a part of the sleeper cell and had been recruited and radicalized by the leader of HNLC to carry out nefarious activities in the district. He also revealed that he was in touch with the members of HNLC from Bangladesh. On the direction of HNLC members, he hung the HNLC flag at Yo Maolong Junction, Nongpo, and crisscross way under the national NHAI signboard. Further, he was part of the conspiracy to conduct the explosion and was aware of movement of A1 Damanbha Ripnar throughout the time. So he was part of the conspiracy, and in pursuance of this, my lord, he has also hung the flag of HNLC in the signboard of NHAI in the national highway, my lord. Now, here in the same page, page number 40, below, my lord, last line, revelation of more explosive. During the course of police custody, all the 4 arrested persons were thoroughly interrogated, where one of the accused, A1 Damanbha Ripnar, during interrogation also revealed that he had received a firearm from the member of HNLC, which he had kept hidden in his house. Further, he was willing to voluntarily lead the police team in the presence of independent witness to the locations to reveal where he had kept all the above noted items. Accordingly, independent witness, namely so and so. Now, my lord, may kindly see the last portions. A1 Sri Damanbha Ripnar voluntarily led the team to his house and showed the place where he had kept the explosive item and the firearm. Accordingly, disclosure statement under so and so sections was recorded. Now, what was the recovery? Recovery of explosive items, firearms, and flags. The first item which was recovered is 5 gelatin stick. This is a separate recovery, my lord. 5 gelatin stick level so and so, 7 numbers of non-electric detonator, 1 igniter safety fuse commercial, 1 country-made revolver, 2 numbers of flag bearing HNLC letter and emblem color red and blue with side star, 3 flags, 8 flags again, my lord, one of different size, my lord. These are many numbers of flags were recovered of different size, my lord. Now, my lord, may kindly see page number 52. All these detonators, my lord, which were found, detonator were diffused in situ by bomb disposal units, and thereafter, my lord.
No, you lead only to the part where there is a reference to E2.
Now here, my lord, page number 54. Page number 54. These are CDR analysis, my lord. Page number 54. I'll just take your lordship to the last paragraph. The frequent contact between him and the other accused corroborates the statement made by the arrested co-accused in the above case. Further analysis of accused A5 Sri Samuel Walang passing to mobile number so and so revealed that on 8/2/2024 he had a meeting with accused Damanbhai Ripner, which corroborates with the statement made by Damanbhai Ripner that he had a meeting with A5 Samuel Walang alias Badeng and received the explosive substance from him on 8/2/2024. Now, my lord, these are the analysis of the call record, my lord. My lord, here there are two numbers, last being 208 and B party, my lord, will see last number 962.
Yes.
These two numbers, my lord, this has been referred in the FIR. It belongs to whom? So accused number 2, my lord, for whom the applications for bail has been filed today, he has been in constant in connection with the accused number 1 as well as accused number 5, my lord. They are part of the conspiracy. Now, page number 55, it says, my lord, severe analysis of A1 Damanbhai Ripner mobile number revealed that the location of the accused on 10/3/2024 shows that he had visited the intended PO, place of occurrence, at around 2 p.m. to recce the place where he had intended to put the IED. At around 9 p.m. he switched off his mobile phone and proceeded from Umsning to Nongpo, where he attempted to detonate the IED at the PO, as shown in the CCTV, but reluctantly aborted the plan and returned back to the Umsning. The above severe analysis of time and locations corroborates with the statement made by the accused persons. Now, the place where they wanted to do the bomb blast, my lord, that place has been visited by A1 and that has also been recorded in the CCTV, my lord. And that footage has already been seized, my lord. Now, if my lord will come to page number 60, the last portions, my lord, it says, it is to be noted here that on analyzing this above CDR, it is learned that most of the calls were made during the month of August 2023. Thereafter, most of their communications were made through WhatsApp conspiracy. Further, it is to be noted here that as per the statement of the accused, Sri Samuel Walang, passing to alias Badeng, and Sri Sanbor, had directed the accused persons Damanbhai Ripner, Robinus Ripner, the petitioner herein, my lord, and Sri Nishalson Taryang and Sri Shining Nongrum to converse only through WhatsApp, and thereafter they had asked them to delete the call and messages. The conspiracy and planning to conduct the explosions was all done through WhatsApp as per the directions of Sanbor and Sri Samuel Walang Pasantu. However, all the call messages have been deleted. The mobile phone have been sent to CFSL for extraction of deleted data, and if any recovery is made possible, then the same will be presented. My lord, may kindly come to page number 73. And the relevant part is at page number 74. The second paragraph I'll read, my lord, from the right side. It says, my lord, during investigation, it is ascertained that A2, Robinus Ripner, is part of the sleeper cell and had been recruited and radicalized by the leader of HNLC to carry out nefarious activities in the district. He was found in touch with A6, Sanbar Pala, through WhatsApp. On the directions of HNLC members, he hung the HNLC flag at Yomaolong Junction, Nongpo, and Crisscross Way over the NHAI signboard. Further, he was a part of the conspiracy to conduct the explosion and was aware of the movement of A1 Damanbha Ripner throughout the time. Accordingly, a prima facie case under section 120, 121 A IPC read with 10, 13, 18 UAPA Act and section 5 and 6 of the Explosive Substance Act is found well established against him. Now, my lord, as far as the role of the accused person for whom the bail has been filed, from the record, from the report which was submitted under section 173, it is very much clear that he was part of the conspiracy from the very beginning, and he knows the the movement of A1 from whose possession the IED was recovered. So therefore, there is substantial evidence to show that there is a prima facie case, my lord, which is against the petitioner number 2, my lord, against the petitioner herein, my lord, accused number 2. Now, as far as, and therefore, my lord, because there is prima facie evidence, my lord, the bar which is provided under section 43D5, my lord, that will come into play. And my lord, the contention which has been raised by the petitioner that there was no notice, there was no information that was given at the time of his arrest. If my lord will see the arrest memo which is there in the petition, my lord, page number 13, my lord. Page number 13, serial number 8.
Yes.
I'll just read out, my lord. The arrested person, after being informed of the ground of arrest and his legal rights,
Yes.
was duly taken into custody on 12/3, if I'm not wrong, my lord, 2024, dated at around so and so at Nongpo PS. The following articles was found on physical service, my lord, no article. And my lord,
No, but this relates to A1 only.
this relates to, my lord, Robinus Ripner. My lord, may kindly see serial number 6. Serial number 6 in the same.
Yes, serial 6, Damanbha Ripnar.
My lord, is in page number 13.
13, yes.
My lord, may kindly see.
Annexure 2.
Yes, my lord, may kindly see the serial number 1, 2, 3, 4, 5 from the left. Particulars of arrested person. 6. Serial number 6.
Page 13, isn't it?
Page 13, my lord.
1, 3, no?
Yes.
Here, 1, 3, Annexure 2.
If I'm not wrong, my lord, we are in this arrest memo. Page number
Yes,
13.
arrest court
/ surrender form.
Yes.
My lord will see this page number, serial number 6, particulars of arrested person.
Yes. Name, here the name is Damanbha Ripnar.
Oh, my lord, probably my learned friend has given
Perhaps a wrong arrest memo has been
wrong
done.
arrest
But
memo.
I do concede, Lordship, that Robinus Ripna, the same condition which Mr. Paul is raising.
Why you have not?
There's a mistake on his part.
Just
my
the
lord.
name, Your Lordship. Everything else remains
And my
the
lord,
same.
if we'll see,
Okay.
Just the
just
name.
if we'll see, my lord, just give.
Okay, you can continue.
Yes. My lord, may kindly have a look at the arrest memo of A2. That is the one, my lord. Here, particular of the arrested accused person, my lord, that is Robinus Ripner, serial number 6. And if my lord will come to the next page, that is page number 14. That is, my lord, my lord may kindly have a look at page number 14. No, in the same one.
14, okay. Maybe it's the same because.
No, it will be different, my lord, because that belongs to different accused person. Page number 14, my lord. Page number 14, my lord, serial number 13. Name and address of the witness. Now here, witness number 2 is the wife of the accused number 2, who is the petitioner in this case, my lord. And therefore, Therefore, the ground which has been taken by the petitioner that they have not been informed about the arrest. Now, the very purpose of incorporating that provision in the Act is because, my lord, to comply with Article 22. Article 22 of the Constitution.
Yes.
My lord, Article 22, my lord,
Yes.
it says that no person who is arrested shall be detained in custody without being informed. The very purpose of this, my lord, it says again, my lord, as soon as may be of the ground for such arrest, nor shall he be denied the right to consult and to be defended by legal practitioner of his choice. The very purpose of incorporating the provision in the UAPA Act is that they comply with Article 22, and that reasonable opportunity is given to the accused person to be defended by a counsel, my lord. Now here from the very beginning, my lord, the accused person has engaged a counsel. They have moved 5 times bail applications before the trial court, and therefore the ground which they have taken, the very purpose for which that provision is there, my lord, that has been fulfilled, my lord, because they are totally aware about his arrest, and they have already been he has already been defended by the legal counsel, and therefore that on that ground, my lord, I do not think the bail has to be considered. Now, my lord,
See, Mr. Sikar, if I recollect correctly,
my lord,
the last occasion when Mr. Yadav has submitted grounds of arrest, communicated, informed, and made known to the accused person are totally different things. Here you have said memo of arrest.
Memo of arrest, my lord.
Because that he was arrested and all things. This was, maybe this witness note to his wife is there.
Yes.
Or rather, she was there. But grounds of arrest,
my lord,
that has not been stated here. On what ground he was arrested? What he says that it has to be in a separate form,
my lord,
and that has to be acknowledged by him.
You printed just now. Now, my lord, they have been relying in a decision of the Honorable Supreme Court, that is Prabir Purkasta versus State NCT of Delhi, my lord. Now, this judgment, my lord, this decision has come recently, whereas the accused was arrested prior to coming of this order. This order came only in May 15, 2024, whereas his arrest was on FIR was filed on 11/3/2024, and at the same time, my lord, his arrest memo, my lord, this copy which has been given, my lord, that is not clear, but probably it is on 12/3/2024. So the arrest of the accused is prior to coming of this decision of the Honorable Supreme Court, and moreover,
it cannot be relied upon.
It cannot be relied upon, and very purpose for which the Honorable Supreme Court has said in that particular case is, my lord, slightly different. Now, in that case, my lord, the remand notice was challenged. The remand of the accused person was challenged in that particular case, and therefore that case cannot be relied upon. That is in a different footing altogether, my lord. And moreover, the very purpose of incorporating that provision is to let the accused person know for what he has been arrested, so that he can engage his counsel and he can defend himself. Now here, that purpose has already been served, because he was, as per the arrest memo also, my lord, I have shown, he was arrested, he was informed about the ground of arrest, what it says. And accordingly, after that, my lord, he has already engaged his counsel. From the very beginning, he has been defended by the legal practitioner, and they have already moved several bail applications. And therefore, the ground which they have taken for granting bail on the basis of this judgment, my lord, it cannot be considered, my lord.
Okay.
So, and moreover, my lord, as far as the offence is concerned, my lord, these are of a very serious offence. These are very heinous crime, my lord. Now here, if we have to show any leniency, my lord, there is a greater consequence. Now, in such cases, my lord, the consequences of releasing the accused person is very high, and therefore my humble submission is that, my lord, because the HNLC is a banned organization, the release of the accused person who is associated with the said organizations, and which I have already shown from the record that his involvement is there, and in pursuance of his involvement and conspiracy, he has done many acts, and also hang the flag of HNLC, my lord, in the national highway, in a signboard of NHAI. Therefore, my lord, my humble submission is that, my lord, the accused persons cannot be released, my lord, on bail.
These are the only grounds here.
These are the only ground, my lord, for
Again,
now I have
number
taken.
one, number one that, see, the grounds that you have relied upon, number one is that the accused is named, or rather is
named in the FIR.
Named in the FIR.
Right, my lord.
Number two, the judgment that has been referred that
cannot be relied upon.
Cannot be relied upon. Number three, because of the offences involved and his alleged involvement or complicity. Because of that, so no bail can be granted.
It prima facie shows his involvement, my lord, yes.
So these are the three grounds.
Yes, my lord.
So you are not defending your affidavit in photo.
My lord, affidavits, the ground which I have taken, that is in addition. Now, my lord, the grounds which I have taken is, my lord, that there was no factual scenario.
See,
even though I have not argued.
Whatever you have said in your affidavit,
my lord,
that you have to substantiate by authorities and so on and so forth.
My lord,
by convincing submission. But since you are stressing only on 3 points, that is why I have specifically asked you. If you are stressing on these 3 points, the order will be passed on that basis.
My lord, my affidavit is already on record, my lord. Now, only for
but you have to
my lord, only for the convenience of the court, my lord, I will just take out the arguments. I'll just point it out, my lord.
What is apparent in your affidavit is totally different. There are certain points which,
my lord, I have not argued.
Which has to be, you see, this court has some query on it. But if you are not making any submission on that,
now
I'll not make any query.
My lord, now only for 5 minutes, my lord, if I can just point out to the affidavits which I have filed, my lord. Now, in the affidavits which I have filed, my lord, I have first ground I have taken is that the applications has been filed by somebody else, not by the accused person. So I have relied on one of the judgments, my lord, Amit Ahuja versus Gyan Prakash Bhambri. My lord, of course, this is connected to 482 applications. So my lord may kindly consider whether this can be applicable or not. Now here in my submissions, my lord, the applicant, who is the wife, she is not absolutely aware about the facts of the case, my lord. So therefore, it is always wise that it is preferred by the accused person who has the knowledge about the case, so that he can sign the affidavit. And now, my lord, as far as whether the accused has authorized to prefer the bail applications on behalf of him, there is no authorizations enclosed along with the petition, my lord. Now, the second argument, my lord, which I have raised, that there is no change in scenario, change in circumstances for after rejecting the bail applications which has been preferred in the trial court, my lord. The situations remains the same, and therefore there is no valid ground for filing fresh bail applications, my lord. Now, my lord, the only fresh ground they have raised is that the ground of arrest was not informed to the accused persons, my lord. That I have already argued upon, my lord. So these are the only grounds, my lord, which I would like to rely upon, my lord.
I think I'll hear your reply tomorrow.
I can conclude in half an hour's time.
Time is
1 o'clock already.
Right.
Tomorrow?
Tomorrow morning.
Just for reply.
Heard Mr. Ansarkar Ji on behalf of the state respondent. Mr. Sierra, Learner Counsel for the petitioner, has submitted and he will be allowed to reply to the said argument on the next date as agreed to by the parties. This is matter tomorrow
Highly
for further hearing.
Obliged.
Good day, Your Lordship.